I've seen that.
Just could do that.
Somebody did.
I'd like to see her in some fringe.
Oh, really?
Oh, I know. She probably made her own time.
Yeah.
No, I don't mind at
No, I meant
all.
like,
What if it was?
Yeah. It'd be called beef fringe.
Oh
I'm branding it for
yeah,
her.
because Joe used to do that one, and now he does that.
That name doesn't like specifically.
Oh. Kristen gave me permission.
I'm into like.
Put it there in our
Tell me what you
put things on top of it.
Crazy harassment.
Because we used to
You just come. And I'm gonna walk you up to him, I'm gonna say, listen, my friend, this is my friend who needs the pink dragon. No, he won't. He'll hold your hands.
There's nothing to straighten
No,
out.
I've been thinking about this for a long time. I've been
All right, I think I'll call us all to session.
my high heels that I wear.
You.
Yeah, gotta be good.
So, good afternoon. Thank you for being here. Hope everybody had a good spring break. So, we are on our next session 4. And I just want to do a few housekeeping things. The mics will remain on the whole time, so you don't have to toggle on and off. And you guys already got your lunch.
Yep,
Is
thank
that
you.
correct? Yeah.
Delicious.
And we have one member, Karen Perez, who will be here a few minutes late. So she'll be joining us over there.
Okay.
And then to get started, the proposal exchanges you requested go first.
Yeah, thank you for
So-
that.
so,
Because we have one member who's gonna
Yeah.
be leaving a little bit early,
So
so
we'll turn
thank
it over
you.
to you for your,
Yeah, thank you. It's nice to see everyone. We're in chronological order like normal, so Article 12 is gonna be Katie.
Okay, here is the two. Okay. They go together. Oh. Are you?
Please don't
you
forget
want-
Karen.
or do you mean?
Oh, good, everybody knows. Article 12 has two different sections coming around. Thank you.
I was gonna say. I heard about the I think it could be a few months. Sorry, I think those might have been my keys. James in the microphone.
All right, do we all have 2 copies in front of you? Okay, so I'm gonna walk through these essentially simultaneously. What you have before you is Article 12, as well as Appendix J. We thank you guys for answering our questions that we had about the transfer process, the Job Expo, and this is our offer to kind of meet the concerns that you have, and while at the same time codifying a lot of the stuff that doesn't relate to the Job Expo back into the contract. Our thought process being that, you know, whenever we settle this contract and we go to the next bargain, if the players who are at the table currently aren't here, we do want some of the things not pertaining to the Job Expo to already be reflected into the contract. So, that being said, you'll see at the top of Article 12 that Article 12B through F, as delineated below, are going to be held in abeyance and replaced by Appendix J for the life of this contract. So Article 12, looking at Article 12, we'll start with A. Those are the definitions that we want to include here around assignment, vacancy, and transfers. You'll note the substantive change for transfer is that for grades K through 5, a change in assignment of more than 2 grade levels for classroom teachers shall also be constituted a transfer. So now we're going to hold the next few sections in abeyance in the article and move over to the appendix. So if you're looking at the appendix, we start with some definitions around staff preference survey, FTE allocations, class size committees, forecasting, net decrease, total bargaining, and total bargaining unit member FTE. These are all things that are defined through or referenced throughout the Job Expo, and we wanted to make sure that we were clear about what we were talking about. B talks about preparing for assignment, and so no later than January 15th, the district will administer a virtual staff preference survey, and no later than February 1st of each year, the district will communicate anticipated FTE allocations to administrators and the association. Again, we want to emphasize that we are committed to helping our members know as early as possible what their assignments are going to be in order to create stability within our work sites. Flipping the page, you'll see on 3 that we have struck in B. That is because in this meeting, we don't need to discuss the timeline for the staff preference survey because the staff preference survey would have already occurred. In 4, we'll say no later than February 22nd. This is when elementary class size committees will meet, as well as the secondary forecasting, and make their recommendations based on the FTE given. And then we also talk about in the event that a worksite will be decreasing FTE, that the administration will be soliciting volunteers. If there are more volunteers than there are needing to decrease, then we'll go on seniority by start date in the district. 5 is prior to initiating the job expo as described below, that the district may hire a licensed temporary employee into an open vacancy that they have. We think our temporary employers are super valuable to this organization, and we know that also building admin want to be able to rehire those temp employees that they have if they can. And then 6, no later than March 15th, administrators will communicate tentative assignments to bargaining unit members. Again, our members have a lot of anxiety and stress around not knowing what their tentative assignments are. And so the earlier we can communicate these tentative assignments, the better. So C goes into the job expo, and we said prior to spring break, the district shall hold a job expo. And that we want the other change is that we want the vacancy list to be posted for 10 days instead of 5. This gives our members more time to think about the positions that are available to them to participate in the job expo and really make an informed decision that makes sense for them based on, all of the different scenarios that go into it. Obviously, you'll also see as you go through that we've changed employee member, all of that to bargaining unit member as we have talked about previously. 2, again, is going to that previously agreed upon language in the MOU previously that attending the job expo does not mean that you are agreeing to or interested in a transfer. It just means that they are exploring their options. For 3, upon completion of the interviews, the bargaining unit member will and do a virtual preference survey indicating places that they would like to match at. At the same time, administrators would be choosing the people that they have interviewed and making those matches, and that HR will receive the results of those match surveys and make as many possible matches and find homes for people as possible. And in the event that a member does not make a match through the job offer, there will be given an opportunity to stay at their current work site, or if there is going to be a decline in FTE at their work site, that they will be given notice that they are going to be potentially involuntarily transferred. On 4, you'll see that we have left plan of mentorship. We totally heard your guys' concerns about the confusion around there, and we're open to a different word. We're trying to get away from having 2 POAs. And so if you have a better idea, we are open to hearing what your idea for a word is. So, placement after spring break. So this is after the job expo. After all job offers has been accepted or declined through the job expo, as talked about above, anybody who's involuntarily transferred can express their preferences to HR from the known vacancy list. So this is where we would give people who are being involuntarily transferred a new known vacancy list and let them give their preferences via virtual survey to HR. And HR will then take those preferences and make as many matches as possible. On 2, and talks about during the time period between February and August, this is the bounce back clause that we have previously agreed to in the current MOU that we are operating under. And all of the language that we have MOU to that MOU to the MOU. And then an E, under involuntarily transferred, we have struck in specific to the individual being transferred and made it initiated by human resources to resolve personnel concerns. So it's just more specific so people have a better understanding of what those, extenuating circumstances might be. Going down to the bottom of E5, we have stricken that line because it is being included in a different place. And then at 6, we have added provisions in this section do not apply to bargaining unit members transferred as a result of personnel action or initiated by HR as a part of a personal situation necessitating a transfer. And then F is all of those bargaining unit member changes except for, again, that plan of mentorship, which, again, we're open to a different phrase if you have one. And then a lot of this, what you're going to see now, is stricken from the MOU because it is now being back into the article. So if we go back into Article 12, and we start with informational opportunities, that is just current contract language. F, the new F, so we're looking at 12F on page 3, under assistance. So we are again proposing that bargaining unit members who are notified of a transfer by the last student contact day will receive 1 day of extended pay. If you are notified of a transfer by August 7th, and we changed that from the 14th to the 7th to reflect our earlier start date. But after the last student contact day, you will get 2 days of extended contract. And then anything after August 7th, you will receive 3 days of release time. This is because we believe that when you are transferred, you have the responsibility to pack up your entire classroom and unpack it, to set up a new space, to possibly learn new curriculum, to get to know a new school. And a lot of this takes a lot of work, and we believe in compensating people for the work that they do. And then if you look under F3, this is where is that language around that if a member is transferred into a new school or expected to deliver a program and when they have little to no experience, the principal and the member can create a plan for professional development, and that plan will be available in writing upon request by the member or the association. And then H is about the trading work sites. Thank you.
Were there any questions about Article 12?
Katie, that last part, the trading work sites, did you make changes or is that just lifted from the previous?
It's just lifted from the previously agreed upon. It's just, it looks bold and underlined because we are moving it out of the MOU into the article.
Say that again?
I said it's bold and underlined because we're moving it out of the MOU into the article. So a lot of the article language is previously agreed to, but because we're making the move, it is technically new language to Article 12.
Thank you, got it.
Any other questions?
I do.
Yeah.
I have a question on, and I probably have some more, but on the placement on D for the actual, the appendix. In D, you talked about it's D2, where you changed it, I think originally you proposed August 1st, and then you changed it back to August 15th, but I didn't hear why, and that was just the, I believe.
Erica, let us get back to you on that.
Okay.
Any other questions for Article 12? Okay, then we're gonna move on to Article 13. I'm gonna pass my mic really quick, sorry for any kind of weird.
Okay, does everyone have a copy? We're good?
Oh, thank you.
Okay, so we have moved toward you guys, we believe, in terms of Article 13A. We have returned to something more closely resembling the original contract language with the addition of a significant reduction in available funds in A, 1A, and a significant reduction in pupil enrollment in A, 1B. And our reason for doing that is, I think it codifies a commitment that BSD has already sort of implicitly lived up to throughout the parties' relationship, which is layoffs are the last final rail, that everything else is attempted before that, and that we would want to underscore in the contract which is as much a document about the party's shared values as it is a legally binding document, that it shouldn't just be for any old blip in student enrollment, which is variable and volatile sometimes, or any dip in revenue. For number 2, we have a different date effective for the layoff. We want the effective date of layoff, we sort of changed the framing here and decided to opt for a noticed by date. The noticed by date is now April 2nd, which roughly about 60 days from the end of the contract year. And the significance of that is we want, if the unthinkable and the regrettable happens and a layoff is necessary, we want to position BSD's employees as well as possible to find work in other districts. And as we've discussed, other districts have early hiring and posting windows. This is a kindness that we think is due our employees, is giving that level of notice. And if the scope of the layoff alters in the intervening months, that's why we have recall language. Recall language exists for that purpose. Going on, no real significant changes except for, if you look at 2E, we've heard you, and we believe that registered is probably a solution in search of a problem. And the parties understand what the current contract language has served the parties well. So we don't necessarily see the need for clarification. And then everything else reflects our mutual movement towards each other in terms of clarification throughout the rest of the article. Any questions?
No, just give me 1 second.
Sure.
Emily, I'm just wondering about the use of the word significant.
Mm-hmm.
If you can think of, I don't know if this is fair to ask, but what would an insignificant reduction look like?
Well, I mean, I would say something like within 5% something, or we can talk about a standard deviation. I mean, I'm open to different statistical measures, but we want it to be outside the norm. Something really substantial. Yes,
I have a
please.
question about the nurses' language.
Sure.
Are nurses or CNAs or people who serve in specialized classrooms that are covered under the classified contract, are they also called nurses or are they delineated differently? Because I think that's the reason we added the registered in there, is to clarify between a classified and a certified position.
I appreciate that information. They are also called nurses.
Okay. Thank you.
Can I maybe paraphrase what you were saying on that particular point, and you tell me is it that you feel that's not necessary because this contract only applies to your bargaining unit members anyway, and so anybody who's in another bargaining unit wouldn't fall, regardless of their title, wouldn't fall within one of these provisions? Is that, you said it was a solution in search of a problem, so I'm just trying to make sure I understand that.
I want to be very thoughtful about my response, so I'll get back to you after
Okay.
caucus.
Sounds good. Other questions?
Okay, thank you.
Yep.
The next article is 19. These are from Addison. Does everybody have a copy of 19?
Yes.
Excellent, thank you. Oh, nope, not yet, sorry. Oh, Mike doesn't need one.
too.
Yeah, she can.
There was a 13 in with the 19 though.
Oh,
I'm surprised.
little bonus there,
I'm gonna
Susan.
greasy it.
Does everybody have a copy of 19 now? Excellent. Thank you. Allison.
Okay, so Article 19, the group insurance benefits. BA's worked really hard to progress significantly to meet the district on this issue, and we know that it is a deeply felt shared value to have healthy educators that can serve our students. And we also recognize that it is a recruitment and a retention opportunity for ESD. So if you look at B and you look at 1A, we have come to an understanding of $2,126 being the monthly premium contribution. This reflects a $300 increase from our current cap. And in B, we have $2,376 as the monthly contribution, which reflects a $250 increase. These numbers were arrived at based on the District Insurance Committee meeting information. And we feel also reflects, again, the shared values that we all have to provide insurance for our employees. In 2, we also have added in the event that the premium for any plan increases more than 10%, year over year within 2 weeks, that the parties will commence negotiations regarding the insurance cap unless waived by mutual consent. We feel this is an incredibly reasonable proposal, and that's the change that we have in that area. If you move to H, the flexible spending account, for one, we have agreed to your proposed language on that. And then finally, when you move to the back side of H2, we have also agreed to accept your changes on that. And those are the changes. Are there any questions?
I have a question, probably mostly because I'm not part of the insurance committee, so just a curiosity of mine, when you look at B2 and you have that trigger, the 10% trigger, was that hit this year? Did rates go up by more than 10%?
Yes.
Am I correct in assuming that that would not, you're not anticipating then to reopen negotiations on these insurance caps for next year after we settle it for next year?
Oh, I get it.
Do you know what I mean? Or is that a poorly asked question? Okay.
Let us think through our answer on that to make sure that we have the right one for
Okay,
you,
so,
and we'll get back to you.
and just to be clear what I'm getting at, like let's say we agree to whatever number X, but we have this 10% escalator in here. So we ratify the contract and we say, whoops, now we have to reopen on insurance because it went up by more than 10% this year. But we already know it went by more than 10% this year, so it seems like we could bargain with that knowledge, so.
Can I clarify?
Yeah.
Make sure I'm under, because I think I'm getting where you're going. What I think I hear from you, Brian, is does the language in 2 around a 10% trigger, would that impact the 24-25
Yes.
insurance rate agreement?
Yes, correct.
Okay, thank you for.
Yeah, thanks, that's a better way to say it, so yeah. Thank you,
We'll get back to you with an
Okay.
answer on that, Brian.
thanks. That was my only question, thank you.
All right. Do you guys want to move forward with ours then?
Sorry,
Yes.
we have one more that we'd like to
Oh,
present. We
great.
have a MOU.
Oh. No,
Sorry.
the presentation.
Sorry.
You can start passing it out, I just need to.
Suzanne, I thought the MOU was the 12.
No, you're,
Sorry.
sorry that I wasn't more clear, Janine.
I have to steal control of the TVs. You got it. Oh, do I need to be in front of a microphone?
Yeah.
I guess I'll just stand in the middle and
There's a
gesture.
portable one. Do you want this one?
But we have mics in the room.
Do you wanna stand?
Can I speak? They'll pick me up if
Portable.
I speak loud.
But does she need a mic?
Do you want?
Handheld.
I'll just carry, this one is handheld. I'm holding it in my hand. This is-
The price is right. Lindsay, I have this one too, if you'd rather have it.
It's fine, but thank you, Shelley, I appreciate it. Okay, we wanted to talk through, just to give a little bit of context and explanation about what this MOU is. So please, look at one of the many. I'm not used to dealing with this many screens, that's why I'm confused. Okay, so in the land of payroll, what is happening now? Here is a big bag of money that represents our total annual salary. And for certified members, that is 194 days. We are paid for 194 days per year. That annual amount is divided into 12 equal paychecks that are delivered to us throughout the year, and that first paycheck starts in August. So what that means, here are the months of the year. The actual days that we work per year are as described there. So in August, we only work 9 days, September 21 days, October 22 days, etc., etc. Regardless of how much is worked during each one of those months, we are paid an equal amount, so 16.2 days approximately for each month. So that pay is amortized, whatever that word is, across the year. So why does that matter? Everybody's getting paid, right? Not a big deal. What are we even talking about? Here's the problem. For folks who go on unpaid leave mid-year, so for example, here's the first 6 months. Say something happens and somebody is forced to, in January, they didn't work 21 days. They were only able to work 7 days. And they run out of sick leave, they run out of PTO, so now they are on unpaid leave. What has happened, if you add up the days that are paid versus the days that are worked, there ends up being a differential. So that person is paid for 96.6 days even though they only worked 88 days. This means that that poor person now owes the district 8.6 days of pay. I just went right in the middle there for step 10. That's approximately $3,390. That's a nasty surprise. Presumably, if somebody is going on unpaid leave, something is happening in their life that is stressful. This is not a great surprise to be receiving in the midst of all of that. So, what we are proposing, we're still proposing an annual salary for 194 days. That annual amount is still divided into 12 equal paychecks, but what we are proposing is that we shift the start to September. It is our understanding that that is the practice of most of the districts around us, that those folks start pay in September, so September through August, instead of starting in August. This helps that person who is going on leave, that unpaid leave mid-year. So here's the same situation. That person has only 7 days of work in January. If the pay is not started in August, but the pay is started in September, now the differential is the other way. There's no surprises. So that member does not go on unpaid leave and then realize, oh my goodness, I owe thousands of dollars back to the district. Instead, they'll get their full paycheck for January, and then they'll get the extra 7.6 days of pay that they are owed. So no surprises, a lot less stressful, and we're in alignment with all of the other districts around us. So here is a fun visual representation. The blue box is 2023, 24, that is this year. Our paychecks August through July. And then the red box, 2024 to 2025, that pay would start in September and then carry on through August. That is our proposal. Now you might notice something. I noticed something. What's going on in August? There are no dollar signs next to August. So part of our proposal is to go ahead and give a one-time stipend equal to whatever the this year's monthly pay would be, so that there is no interruption in a paycheck for members. Because otherwise, folks would not get a paycheck in August, and that is, talk about stressful. So we're proposing a one-time stipend. The way that this would work out by our math is folks wouldn't really notice anything was different, because they'll just be receiving paychecks, until they left the district through retirement, resignation, or whatever. And then they would receive, oh, there's that extra August check, that when there was a shift, I'll get that extra paycheck when we leave. So this is kind of a benefit that from the district budget-wise, Mike, you can correct me if I'm wrong, is felt after the fact. So we feel like this is helpful to our members. This is also beneficial to the district to be in line with other neighboring districts, to make sure that we're not running into those leave situations. We've had several of those happen, and it has been problematic. So we feel like this is a benefit to the district as well. We also feel that we know, math doesn't lie. We know that in August, we're actually saving the district a bit of money, because the August stipend would be on this year's pay, so that step and COLA would not be realized in the August paycheck. It would be realized in September. So the current year's budget would actually be saving a little bit of money. To that end, we are also proposing a $1,500 one-time bonus in August 2024 to offset those delayed step and COLA increases. So for our members, that's not a long-term addition. In terms of adding a COLA, it's just a one-time payment to offset that reduced paycheck that folks would be accepting in August. And then this is all explained in words in the MOU. And I just want to call to your attention that the agreement shall be effective upon signature by the parties. So if we, I don't want to put this energy into the room, but if we don't settle this ahead of next year, we can sign this MOU separate from the entire bargaining process and have this for members moving forward next year.
Can I ask a quick clarification?
You sure can.
Can you go back one slide? So, with regards when you were presenting, first of all, you said, okay, we wouldn't start pay till September, correct? And now, then you added that they would get a stipend in August. So I'm right in saying that's additional monies on top of what they're getting, that they'd be getting in their salary? Or is that all spread out through?
So it would be the 194 annual salary for this year would stop in July.
Right.
The 194 day salary for next year would start in September. So August would just be whatever our daily rates are. They would receive their monthly salary just one time.
Not additional pay, just part of their collective pay, like annualized pay?
No, it would be an additional,
That's what I wanted to
yes,
get. Okay,
yes.
yeah.
Thank you for that clarification. That's right.
Fill the gap.
To fill the gap.
Yeah, and then can you skip forward again? So then this is what you were talking, this would be different?
Yes, so this is in addition to that, because what we want our members to feel, as is outlined in the MOU, we don't want there to be an interruption in pay for members, so we want members to, essentially we want this, which again we see as a benefit to both our members and to the district. We want this to feel like nothing is happening. And we know that since we're proposing that August one-time payment is on this year's salary, folks usually in August, that's our new step, that's our new COLA. So we're adding this $1,500 stipend to that so that there's an offset. So if folks are planning on that increase, there's that one-time payment
In addition.
in addition to.
Okay, thank you very much.
Any other questions?
I have one. If you go back to that previous slide, I just want to make sure I understand. So that August of '24 would be the one-time stipend. What we don't show on there is that there's actually an August payment that affects my 24-25 budget in August of '25. Because from an accrual perspective and accounting perspective, the cost in August of '25 would be attributed to the work done in the '24-25 school year. We can sidebar if you need to or have further discussion around this, but I just want to be clear about that actually there would be 13 payments in that year.
Can you tell me why, Mike, that would,
Yeah, so under the same annualization concept that we're talking about, we take the 194 days currently and we end it in July. It would be extended to August because we would be dividing our payments from September through August. So that work would be, what we use a modified accrual basis of accounting, so that work done, we would have to include in our 24-25 cost in terms of our annual financial audit, because it was work performed during the 24-25 year, even though it was paid out after the fiscal year. So similar to what we do now, we accrue back that July payment into our June 30 financial statements. In this case, we would do both July and August as an accrual back into the 24-25 financial statement.
okay, I think I understand you. I might have
We
more
can chat
questions for you later.
Yeah, happy to.
Can we have a copy of this, of your
Absolutely.
wonderful graphics here?
Yes. Thank you. I think I want to thank you.
Janine, that is everything for us at this time. Thank you.
All right, thank you very much. Does our team want to continue with our articles?
What's that?
Want to continue with our articles then, right?
Yeah.
Sure. Oh.
All right, everybody have Article 6? Great. I think we were narrowing the gap on this article and we're getting down to perhaps one issue that we were still working on, because through the prior exchanges, we had agreed to a change in the title at the top. We had agreed to the deletion of current section A. So dropping the next paragraph would become new A. The piece that we were still working on, you had proposed a limitation on which complaints could be utilized, could be used against the employee in any subsequent action brought by the district. So we have the 30-day timeline, but you had proposed a qualifier related to the execution of a member's assigned duties. And I think as we discussed last time and provided some examples of off-duty situations that might be a concern to the district, the fact that sometimes there is a blurred line between on and off duty, and there are interactions with students that happen off duty and things of that nature. So we've provided a counter proposal there in that first paragraph that incorporates the related to the execution of a member's professional duties, but then builds in another set of examples of scenarios where a complaint may be relevant. I mean, I think all of these are intended to get at the idea that there's some nexus between the behavior and the work environment or the job responsibilities. So there you'll see the reference to work performance, school operations, student relationships, statutory responsibilities, which would be the TSPC rules, or otherwise related to work. So we are a little nervous on this one, again, because every situation is a little bit different. The facts are always a little bit different, and coming to a conclusion of is this sufficiently related to work to be relevant can be very fact specific and very difficult. So we are trying to make that expansive, more so than in your proposal, to make sure we're covering all of those possible situations. The strikeout in that paragraph we've both agreed to. And I don't believe we have any disagreement on what would become B. So I think it's only that language in that first paragraph we're still working on.
Thanks, Brian. We don't have any questions at this time.
I have one clarifying question.
Oh, sure, Allison.
In the new only complaints, you have only complaints from parents, and then you crossed out citizens and then put the community members or staff members. In our original, we just moved, to the community members. I wasn't sure if parents was left in intentionally or what was meant there, if you want parents separated out from community members or other staff members.
Yeah, thank you. I don't remember that being a topic of our conversation as a caucus. So, and honestly, I didn't remember that you had deleted parents.
We hadn't deleted it, but we have slightly different wording, and so I just wanted to know if that was purposefully left in, if they were not considered to be community members within that definition. It's just a clarifying question.
Yeah. I don't know that I see a lot of significance there. I mean, I think that parents would also be community members, but I don't know, folks on our team, if you have any other thoughts on that. I remember the piece that we had been primarily concerned with there is replacing citizens with community members because it was more inclusive. But other than that, I don't remember a lot of discussion on our team about that definition.
Thank you.
Allison, I'm looking at your counter on P14, and it does have parents, and we have parents. Am I confused? No.
It's fine. My clarifying question is just, you have replaced it with community members or staff members in your proposal, but you've left in parents, and so I didn't know if there was a reason to have them separated out from your new proposed language of community members or staff members.
No, I don't think there was anything intentional in there other than that was already used in the current language. So our replacement of citizens for community members was as deep as we thought about on that piece of this.
And Allison, the staff members are listed as new language only because it's replacing the strikeout that comes after district. So it truly is like, the change here is from citizens to community members. The parents were current language, and so were staff members. It just rearranged the order. Does that make sense?
Yes, I understand the rearrangement of order, but again, my question is simply, do you want parents separated out from community members?
Gotcha.
That's all.
I think, at least at the elementary level, often we have community members who are not parents of students in our schools that are involved with our schools. So that might be something to consider.
Might be a reason to have those separate.
Can I just quickly note that if you're asking a question, if you could pull the mic to you, that'd be super helpful. Thank you.
Thank you. We don't have any more questions about this article.
Okay.
Okay, we have Article 8. You passed out.
All right. There's a lot going on in Article 8. It's kind of a lengthy article, and so I'm going to walk through this. I'm going to try and hit places where we didn't incorporate your language as well. If I've forgotten something, please just ask me what about, X or Y. So trying to be comprehensive about it. Article 8, there's nothing substantive going on in A1 or A2A. You'll see in A2B, if you guys touched on it briefly in your presentation, this idea of do we rename plan of mentorship so we avoid the duplication of of those acronyms. And so we've kind of gone about it the reverse way, keeping it as plan of awareness, which would be a POA, but clarifying that plan of assistance for improvement would be a PAI. We tried on a number of different possibilities for plan of mentorship and didn't come up with any good ones, so that's where we landed. No intended substantive change from current practice, just a name change. Touch a place where you had proposed change that we did not pick up. There at the tail end of that paragraph, that talking about if people would be placed on a plan of mentorship or awareness rather prior to being placed on a plan of assistance, and the current language says except in cases where a contract employee has been on a plan of assistance. So for us, that language is important because if we've gone through that cycle with somebody, plan of awareness, plan of assistance, they've successfully completed that plan of assistance, but let's say 6 months later we have performance problems again, we don't want to start back at the beginning. Plan of awareness, then plan of assistance again. We feel like there's been that plan of awareness. And in saying that, I'm contemplating that the deficiencies are the same ones. That for us, it wouldn't make sense to go back to square one. Instead, you would be more likely to go straight to another plan of assistance if you went to anything, I suppose. So that's why we've not picked up that change. We do have a proposed strike through in section 5, that's current language. As I look through that, that's one that came from my review, where it talks about depriving any employee of legal rights of representation under the Constitution of the U.S., state and federal statutes, et cetera. I mean, we've described all of them already. There are no additional rights of representation other than what we've described above. So it just, to me, the language is unnecessary because it doesn't apply to anything. So we propose to delete that to avoid confusion.
And the Constitution would supersede it.
True. And folks on district side, feel free to chime in as I'm going through this if I'm missing any pieces of this. Evaluation of students. We had proposed the add of unless the employee is unavailable. So now I'm looking at the sentence that starts, no greater evaluation shall be changed without conferring with the employee. And we had proposed to say unless the employee is unavailable. So that would be if we have somebody leave employment with the district, move to another state, something like that, and we're not going to be able to confer with them. You had proposed language there about notice being given, and we've picked the principle of that up, but not really all of the details. So the bargaining unit member will be notified if a grade is overridden by ed administrator. You had a timeline worked into yours. And so, again, we feel like there are times where that change may occur at the end of a school year, or there may be other circumstances where, a 1 week timeline is not possible or might be inadvertently missed. So we've just we agree that notification is appropriate, especially in light of the fact that there's, in the prior sentence, supposed to be conferral unless the employee is unavailable. So we were fine with notice happening. Next section, adverse criticism. You had proposed a final sentence there. Any criticism by a supervisor or administrator of a bargaining unit member's performance will be delivered without individuals except those serving as representatives of the association present. We had some discussion when you presented that about who we mean by individuals. Are those other administrators? Are they non-administrative employees? We tried a different go at this, saying that any criticism, but it's not in front of a bunch of people. It's not in front of other bargaining unit members if those people aren't there as the representative. So this is language that I think I borrowed from another CBA, this concept of those things taking place in a private, confidential setting. No substantive change in that next paragraph. D1, citizenship, no substantive change in either of our proposals. D2, you'll see our proposed language there. I think you had responded or included language about where such materials and methods are controlled by state or federal mandate. For us, there will be things that aren't state or federal mandate that we do expect folks to follow. All of our policies and ARs, and Matt, you can jump in here, but we've tried to identify those that we felt were related to this topic, and that you'll see those there. There's a handful of other ones, as well as the expectations established by the district's guidelines. And so, Matt, could you maybe talk about when we talk about, or anybody on our team, when we talk about district's guidelines, what we might be referring to?
Yeah, I can. I just spent a couple minutes thinking about guidelines that come from the district that are not actual district policies, and a couple off the top of my head. There's reporting timelines, SBLS expectations, considerations, Canvas use expectations, synergy gradebook setup. So it'd be things like that to ensure consistent practice across the system, but are not at the policy level. And I just take a second and just looking at the policy, I'm not quite sure why the previous agreement only listed policy IIA, which is instructional resources and materials, given that it's only one of a handful that are sort of closely related to classroom practices, which is what led us to adding the 4 others that you see listed there, which are in many cases even more closely related to classroom practices than IIA.
Can I ask a quick, Matt, I'm sorry, you speak faster than I write. Could you repeat some of those guidelines that you had mentioned so that I can just make sure to jot them down accurately?
And I do want to say nothing comprehensive, just kind of off the top of my head.
Right, just your ideas, yeah.
We have reporting timelines, which sort of lay out progress reports, report cards. SBLS, and the document is usually referred to as the SBLS expectations and considerations. It's a list of certain practices that we all do, and then there's a list of practices where there's a lot of teacher autonomy around, and that's why it's a sort of a 2-part document. There's also, I think it's maybe 3 years old now, the Canvas use expectation to try and get everyone to, there's actually, I think 3 different levels of Canvas use to try and move people along. And the last one that just came to my head was just the Synergy Gradebook setup. There's a few choices that can be made within the gradebook setup to get either a department or a school around a consistent practice of how they enter into the gradebook.
Thank you so much. I think I got them all this time. I do have a follow-up. Did you have any elementary examples?
Are all those, well, I think, oh, you're right, because Canvas is only a secondary. It's, is it Seesaw?
Yeah.
I don't know, I'm not an elementary guy, so, but I think there's, I've seen at least references to a Seesaw expectations or guidelines at the elementary. Any of you who teach elementary, help me out. No, but that's a good question. I'd probably have to go talk to some of my elementary counterparts to figure out what sort of guidelines exist at that level. Yeah.
Thank you.
Yeah.
No, I mean, I think it depends on the teacher and how they're using it, since it's not
Can you use your microphone?
mandate. Sorry. The use of Seesaw is no longer mandated, so some teachers use it and some don't. So I think it depends on how and why you're using Seesaw at elementary.
Okay, ready for me to keep going? All right. Moving down into section E, protection of employees, students, and property. We have some proposed changes in E1 of how we're describing, it's entitled right now reasonable force. I think for us, we're talking here, the emphasis is less on using force against students as it's more along the lines of physically intervening to prevent injury or damage to another person or yourself. So for us, physical intervention is a better description of it. So you'll see that both in the title and then in the second line. And we also felt that the language of quelling a disturbance was somewhat odd language. We feel like it's preventing physical injury to others. That's really what we're talking about, is when we expect folks to use a physical intervention. Is it necessary to prevent the student from harming themselves, to prevent harm coming to you, to prevent harm coming to a third person? And so we're trying to bring that language more in alignment with that concept. No substantive changes in number 2. Number E3 is our response to your proposal. We had no original proposal here, but you had a proposal to expand this situation where people may be reimbursed. Right now, under the current language, it's limited to situations where an employee is the victim of an assault. And so we've agreed to expand that. You'll see there, so it still has a reference to an assault on the employee, and then we added or other intentional act of destruction. So what we're trying to avoid is a student, slips, spills paint on somebody's sweater, and that's not a reimbursement situation that we're contemplating there. To us, that's an accident that could happen to anybody working in a school environment. We're really talking about where somebody has their property destroyed intentionally by a student, where they are physically injured through an assault by a student. So that was our attempt at capturing those situations where we would see reimbursement being appropriate, knowing that there's a big gray area in there. And we wrestled with this one a lot. How do we describe this in a way that's not too expansive, but that tries to get at those situations where it's not just an assault, but some intentional act to destroy property that you have. So that's where we landed. But again, it was quite a lot of debate and discussion in our room because it's a difficult concept to reduce to writing, I think. Down in 4, we carried that, or deliberate property damage piece, down into 4. We don't have a centralized reporting system right now, especially for damage to property. So difficult for us to contemplate your proposal there of this happening. I think our expectation is it's reported to the building administrator. So we did not pick up that language in the remainder of 4 from your proposal. 5, neither party had a substantive change. Same with 6 and 7. And actually, I think that's true through F, at least 1 and 2, if not all of F. Let me just make sure. Yeah, nothing in F other than wording changes there. You had no substantive proposal in G. We do have a proposal in G2. We find it unnecessary to list the scenarios in which the district might accept a resignation with less than 60 days notice. We think it's kind of the district's up to, right now it says if provided that there are extenuating circumstances and when a replacement is available, et cetera. I think we're comfortable just saying the district has the option to accept a resignation with less than 60 days notice. Non-discrimination, I think we talked about this one the last time we bargained. You flagged, I think, the same problem that we did, which is the current language, when the way it's currently set up in the contract is to avoid a duplication of remedies or a duplication of liability potentially for the district. So on this topic of non-discrimination, because of the wealth of statutory remedies available, BOLI, EEOC, state law, federal law, the current language had it set up that if you filed a grievance and then filed a federal or state complaint, then the grievance didn't move forward, right? Again, I think the idea was to avoid the district having to defend the same action twice. That methodology is not currently legal under Oregon law. And so we did wrestle with this the last time we bargained. You've proposed to delete that current language, and so have we. I think our concern with how you've proposed to leave it is it would have that kind of 2 bites at the same apple possibility there. Somebody could file a grievance, could also file litigation at the same time. The district would have to defend that action twice. For us, this is a topic that for a variety of reasons, we would prefer it to go through the legal system. And, you know, primarily, we're trying to avoid having to defend the same action twice. But we also look at the arbitration system being a fairly informal system where we have an arbitrator who's a layperson. They're not a judge, they're not a jury, they're not bound by case law precedent, they're not bound by statute. So when we're talking about things as serious as a discrimination complaint, we feel like those deserve the rigor of the legal system. They deserve the ability for either party to appeal that decision to the Court of Appeals and so forth, and not the informality of an arbitration setting. So our preference is that we have those situations go through our legal processes. It's not a statement that we're not committed to the principle of non-discrimination. It's really where, if we have a dispute, what is the venue where those disputes are resolved? So that's our proposed way of dealing with our current language, which is not, we can't continue to include in our contract. All right, moving on to the last page. I'm going to turn this portion on section I, physical environment, over to Curtis.
All right. For physical environments, we accept your initial language around the district will comply with state and federal laws and regulations. We really like that language. We think that that is very inclusive of a lot of the concerns that you bring up subsequently, so we accept that initial language. The next part of that opening paragraph, you propose language around responding to members within 2 weeks. We are rejecting that and keeping the current language, which is within 30 days. It can certainly be less than 30 days. The concern with the 2 weeks is if there isn't thorough or information available in that time, we want to be able to provide information that is meaningful as that's available. So within that 30-day window is what we would like to maintain. For the second paragraph, we would like to maintain the existing language. You have added a section of the second paragraph that states reporting requirements per OSHA that would be available to members. OSHA guidelines communicates out and is actually pretty nuanced around the communication parameters. And so we will incorporate that in that opening paragraph by following the state and federal laws. So again, the OSHA guidelines and the Department of Environmental Quality guides a lot of our actions, which are covered under that initial statement about following state and federal laws. Similar in the second paragraph, there was a mention of a demand to bargain process. That is something that we don't feel needs to be called out specifically as an opportunity here. That is something that is always available, and so we don't need to call out when a demand to bargain may be made. That is something that doesn't need to be, in our opinion, called out specifically relating to the quality of the environment. Your number 3 mentioned specifically around temperatures in the classroom and responses to air quality index. Again, our position is we feel those are adequately covered under the state and federal laws, specifically the Department of Environmental Quality. Air quality index has requirements around actions when air quality and also heat indexes rise above certain levels. And so by following the state and federal laws, again with that opening, encompasses much of what is covered subsequently.
Thanks, Curtis. I'm going to pause just right here for a moment in case there are any questions.
We don't have any at this time.
Okay. A few other pieces to cover in the remainder of this. You had proposed it's section K in your contract proposal on personal life. We feel like now with that complaint procedure containing information about what situations, where complaints could lead to action and where they couldn't, we're sort of dealing with that topic in that venue, so we did not include it here. We did incorporate language on job descriptions. I'm going to let Janine cover that.
Sure. So we accepted your language with the exception of the last part where it says current members request a copy of their job description or access from HR at any time. There was a part missing. But anyway, want to let you know that our job descriptions are accessible and they're on our website, intranet, and then they're also available for an employee when they have their new employee orientation. They're given to them at that time. So is there any questions regarding job descriptions?
Not right now, Jean, thank you.
Okay.
You'll note we did not incorporate language. You had provided or proposed 4 sections on evaluation. You know, and this is one where as we worked through it, I think our preference, we've got a number of different sources where rules from kind of high level all the way down to very specific are set forth regarding evaluation. That would be state law in ORS 342-850, and then through our evaluation, and Susan, I don't remember what specifically you call them here.
Timelines and processes.
Timelines and processes. And that's a document that we prefer to see as kind of a living document that can be modified as necessary. It's gonna cover much more detail, in fact, than what you've proposed in M. So we really see that as the place where our information and detail regarding evaluation is more properly located. And Susan, I don't know if there's anything else you wanted to say on that, or anybody on our team for that.
I don't think so. I mean, that's a document that we wrote it together with BEA as part of a previous contract negotiation. And really, the purpose of it is to outline, as it says, processes and timelines, and share a little bit about what our supports are for performance in our plans of awareness, and if we adopt our new language, our plans of assistance for improvement, and other processes that we use to support our licensed staff evaluation.
I believe that I touched on all of the things that were in your proposal and then in ours, but if I missed anything, let me know.
We will, thank you. We actually do have a couple of questions.
Okay.
I believe, physical environment.
Okay, Curtis, you're gonna be up.
All right.
I actually have questions, sorry, it's not physical environment,
Oh,
I lied
so
to you.
Drop that.
To you, Brian.
Just, I think I have an understanding, but I would love to clarify. There are several instances of employee where we want to change it to bargaining unit member and they're not taken. Was that intentional or unintentional as a rejection?
You know, that's been kind of a challenge as we've worked through this to monitor all of that. So
Sure.
I wouldn't mind having some discussion at some point about what's the best way to accomplish
Okay.
that.
But it was not like we are uninterested in the edit.
I don't think that there are any individual ones where there's
Great.
specific, you know, but I'd wanna look back through there because,
Absolutely.
yeah.
I'm not like holding you to it, I just wanted to know, was there like a deep feeling we were unaware of, basically?
Yeah.
The other piece I would love to clarify is in, oh Valley, where am I? A, nope, by life, it's C. C, adverse criticism. At the end of that first paragraph, we had included language around union representation that I noticed was not in your counter proposal, and I wanted to clarify, is that intentional or not?
Hold on, I'm just getting to yours real quick.
A lot of pages, it's super fair.
There are,
It's where you said in private.
Representatives of the association was our proposal.
right. Do you have theirs handy
Yeah.
in front of you? I don't know why. I'm looking right past it.
It's right here, it's just the way they worded.
Is yours intended to mean anytime there would be a criticism, there would be a union rep there? Because I was reading it kind of in a different vein. I was reading it like there won't be anybody else there except for people who are serving as a representative.
I mean, our proposal, as I read it, any criticism by supervisor or administrator of a bargaining unit member's performance will be delivered without individuals except those serving as representatives of the association present.
Yeah,
So in my understanding of that, it's the privacy piece that you were alluding to.
yeah.
But yours carved out the association representatives, and I wanna know, was that intentional or not?
But
I
Does that
hadn't-
make sense? as
Yeah,
a
but
question?
I guess I had just been thinking of it from a different angle, like
Okay.
who's allowed to be there? Or it was more along the lines, not necessarily like, does an employee have a right to a rep in those conversations? More along the lines of these, who should potentially, the only ones there should be the following people. So I guess I'd wanna hear more if we're, sometimes I think about criticisms and maybe an administrator sees something happen and they want to tell somebody like, hey, next time that situation occurs, I don't want you to handle it that way. I want it to look more like this. Like, is that a criticism? And I don't know that an administrator would always say, I need to set up a meeting, and you should have a rep there for that. They shouldn't do that in front of a bunch of students and colleagues, but sometimes that might feel like.
So you have a curiosity around, are we proposing that it is a requirement
Right.
versus allowable? Is that your
I don't
curiosity?
have a problem with it being allowable. Like, I just would be interested in, like, can I not have that discussion contemporaneously? Is that one where I have to say, I'm gonna set up a meeting for this?
Okay.
Which honestly might over-formalize it even more than the administrator ever intended it to be.
I hear you.
Okay.
Thank you for clarifying.
Yeah.
That was it for me.
Sorry. Another question, would this limit criticisms made about an employee in private to parents?
In private what?
To parents.
So
Like an administrator is
Thank you.
speaking to a parent in a critical manner about an employee, is that what you're thinking?
yes, wanted to see how that aligned with your intention in the way this is drafted.
I hadn't really thought of it, I guess the way I'd been contemplating this topic, it was like, I'm having an interaction with you as the employee about something that I perceived to not happen in the way that I wanted it to happen, and I'm correcting behavior so I hadn't been thinking about how this would pertain to conversations I had with other people.
Okay, I mean, I
So I
think
would, yeah.
that was part of the intent of our original proposal, was to also try to make sure that criticisms are delivered to the appropriate recipient, rather than say a principal blow it, it is the time of year when everyone's stressed out.
Yeah.
We have heard recent reports of a principal speaking critically about a teacher to a parent.
Oh, okay.
So I can read that I was wondering if that factored into your intent at all.
No, I hadn't been thinking about those situations. And I don't know if any of our building administrators, I guess from my perspective, that would not necessarily be appropriate to.
Agreed, yeah.
We agree.
And I think, I appreciate that clarification, Emily, because I don't think I got that from your proposal, that it intended to talk about third-party conversations as well. But I do notice that our current language says any adverse criticism by a colleague, of a bargaining unit member by a colleague, supervisor, administrator, or board member shall be done only through proper channels as identified in policy and contract. So I don't know whether that kind of helps touch on some of that.
Perhaps so.
Maybe it doesn't cover everything.
We can talk about it, but I wanted to make sure that you understood what our language was partially coming from.
Okay, thank you for that.
Yeah.
I think that concludes our questions for now.
Okay. We have Article 15, that's gonna take a few minutes for us to walk through. Do you mind if we just take a real quick, 5-8 minute kind of stand-up break? We don't need a caucus, but,
Yeah, that
okay.
sounds great to us, thank you.
All right, thank you.
to go?
Yeah, is everybody back that's coming back? Or are we missing a few of your folks?
We're missing one of our folks. Allison needed to leave early, so thank you for accommodating us and letting us go first so
Sure.
that she could present. But Janine is still, we're waiting on Janine.
Okay, sounds good.
Yeah, she might be in the restroom, but I don't know. She wandered back in when you and I were right there.
There she is.
And we're all here.
Yeah.
Great, thank you. Erica, what did you just send around there?
14 and 15.
Oh, both of them, because
Yes.
they're combined together. Okay, does everybody have that one? Looks like it's finally made its way around. 14 and 15 are being presented together because they are kind of dependent on one another. You'll see 14 is, I think you guys had proposed the same thing, is a proposed deletion of 14, moving it into 15. Pretty sure that you had proposed that as well.
Yes.
Okay, so we're just showing that here as with a note, Article 14 incorporated into Article 15 proposal. So, not much more to say on 14 unless there are questions there.
We have so many questions.
Yeah. Surprised me with 10 questions about that.
I'm so glad you said that.
All right, well, so Article 15 is obviously then a different story. There's a lot going on in Article 15. Leaves, I think, is a challenging article to deal with. We have a kind of coming together of contract leaves as well as all of our statutory leaves, and those keep changing. We just had recent change in paid leave Oregon and OFLA and Oregon sick time, so kind of an evolving landscape, and our challenge as a full group is to make sense of it and have our contract kind of live in alignment with it. So I'll start at the top. I'm gonna try and cover those areas where you had made a proposal as well, and also where we've proposed language. And again, feel free to stop me if I've missed something or if you have a question. Sick leave, I believe the first, what you see there in our proposal was agreed to in your proposal as well, as far as that first sentence. Absence of a member due to their own illness or injury or for any other reason set forth in Oregon sick time law, including illness or injury of an immediate family member. So we're in alignment there. You then went into a discussion about substitutes and people's responsibilities when they had a substitute, which we felt like was two things. It didn't feel like it was appropriate for this topic. I mean, it is a leave issue, I get that, but here we're defining what sick leave means. So it felt a little bit out of place there. We also then had a team conversation about what are the expectations for people in relation to substitutes when we have that type of a situation. And for us, they're very nuanced depending on the scenario. Was this a planned leave? Was it an unplanned leave? You know, how long was the leave, et cetera. And so I was gonna have, we didn't incorporate your language, but I wanted to have a couple of our administrators talk about what they view the expectations to be around, especially the lesson plans for substitutes. You guys had broken it down on the 4 days, or kind of the 4 days or more or fewer being the benchmark. So I wanted to give Matt, and then maybe hopefully somebody at the elementary level can help talk about what we see that scenario looking like.
Yeah, I agree completely. It depends on if it's planned or unplanned. In emergency situations, at least practice in my building and those that I'm aware of, in an emergency situation, then even the plans for the very next day. We don't ask for the teacher. It's the team of teachers, the department, someone who's teaching the same course. We try and cover that immediately just to allow the member to focus on the family issue or whatever is going on. If it's a planned leave, actually a little bit more common practice is doing lesson plans, even up to 10 days, to be honest with you, until it switches over to a long-term sub. And then the sub is expected to do all the planning and preparation, but that only usually kicks in after the 10-day mark. So it really all depends on if it's known or not known. And if not known, we cover for the person. If known, then we just try and plan out as far as possible, but 10 days is the furthest that I've seen.
I concur at the elementary level. We ask that teachers have one day of emergency, just like a sketch outline of their day, and some activities that fall within those particular content areas for emergencies. But if it is a planned leave, we expect folks to, work with their teams or come up with a minimum amount of plans for the time that they're planning to be gone. In the case of an emergency, our teams are really good. They usually plan together at least once a week and oftentimes collaborate multiple times a week around what they're teaching and the activities that they have put together for kids. And so our teams are really good about if we have an emergency, the team comes together and helps the substitute know what's going on for that day so that they can have a little bit more depth and breadth in their instruction beyond that just simple emergency day plan. I think the same goes for us as it goes for high school, that if we have a absence of 10 days or longer and then end up with a long-term sub, that at that point, the long-term sub takes over and plans with the team.
Great, thank you. So, for us then, that left the language you had proposed not really covering our situations, because it sounds like if we have an emergency, it's not even up to the first 4 days that they're expected to have plans. They may not be expected to have plans beyond that bare bones one for day one, right? But if it's a planned out absence, it sounds like 10 days is sort of our benchmark as to what's expected for plans. So, and again, we had a concern about where it was placed as well. So that's why you don't see that language reflected back in our proposal.
I would just add, I think it's clear, but our concern is the continuity of instruction and the experience for the students and the flexibility to accommodate different situations. I think that's kind of what we heard from the building leaders as well. And that is, I think, a mutual consideration, I think, from management and from our licensed staff, is just doing what we have to do as a team to make sure that the student experience is consistent.
Okay, moving down into section A1B. We picked up much of the language you proposed. I don't know that there will be a substantive difference here. I think the only thing that will look different is you had the reference to leave that comes through the sick leave bank. You had that appearing in B sub 1. We moved it up into that introductory paragraph of B, because we believe that if somebody's on sick leave bank, and you'll see we have reinstated the sick leave bank in our proposal. You guys were fairly critical about our proposed deletion of that. Again, I think, we're trying to wrestle with how paid leave Oregon is impacting our absence levels, our ability to have subs and things like that. It is definitely noticeable. So we had wondered about the continued need or utility of the sick leave bank. We heard from you. We're trying to be responsive, so that is back into our proposal. But in this context, we've just moved the reference to it up into that intro paragraph of B, and you had it in B sub 1. Otherwise, I believe that should be, if not identical, pretty darn close to it. And you'll see in A2, that was a concept that I think it was placed later in your proposal. It was placed on the second page of your proposal about retaining access to electronic infrastructure we've specified during paid leaves because that's what this article is paid leaves. So bargaining unit members shall retain access to district electronic infrastructure during paid leaves. We added with the exception of paid administrative leave, when we place somebody on paid administrative leave, like pending investigation, the district does turn off their access to email and systems. I think that is a standard protocol for this district and others. So we're trying to accept out those situations of paid administrative leaves. But otherwise, I've picked up your concept there. You had language regarding utilization of leave under paid leave Oregon. I think we've tried to summarize and be a little more succinct and just say bargaining unit members may utilize accrued paid leave in accordance with applicable state or federal law. That might be paid leave Oregon, it might be OFLA, might be FEMLA. We're trying to not nail down too much in the way of specifics in the contract because we've seen these things change. Very recently, we just had a change as far as order of leave and how much you can use and things like that. So we're wary of having our contract get out of step with the law. So we've proposed a kind of a broader statement there, I would say. Pregnancy, childbirth, we added loss of pregnancy. That was in your proposal. The only reason that of disability is underlined is because it's being moved from, you'll see it's then struck out in the next line down. We've just moved the placement of it. So it's an editorial change only. We had proposed to strike that next section, and you had picked up that strikeout as well in your proposal. We've left in, you had not agreed to this change, we've left in, and really as I read this, it almost feels duplicative with what our proposal is in A3. Bargaining unit members may utilize accrued paid leave in accordance with applicable state or federal law, and then we say here again, a bargaining unit member shall have the right to use paid accumulated sick leave for parental leave in a manner consistent with federal and state law. I think we're saying the same thing twice, so I don't know, we may want to have some conversation about whether we need to have that covered here again, because it does feel a little redundant. Moving on to accumulation, as we looked at this, most of this is not substantive. I think that the piece that is, as you see about halfway in that paragraph, as we are looking at our variety of leaves that we have available to folks, and in this case sick leave, and the fact that we front load, we do run into situations sometimes where somebody might use all 10 of their sick leave days before October is out and then leave employment with us. They technically haven't earned all of those sick leave days yet. And so we've added language to clarify that the district can essentially true up in that last paycheck is how it happens in most districts for that use of unearned leave. So that's in that accumulation section. Extended sick leave, let me just look at this real quick. I think the addition of all applicable leave balances in place of accumulated sick leave, that was your proposal. So we've picked that up.
Slightly different.
How so?
They said all accrued and other leaves, and we changed it to at least change the word. So the BEA proposal for that section in 4, extended sick leave, says upon expiration of all accrued and other leaves, and we just changed the wording upon expiration of applicable leave balances.
Okay, I don't believe there's an intended
No.
substantive difference there.
No, agreed.
Next paragraph, I don't believe has any substantive change. Abuse of sick leave, there is no substantive change. Application to retirement benefits, no substantive change. Sick leave bank, you see that language is back in as current language. I don't believe you had proposed any changes except when we get to the very end. Any bargaining unit member may use sick leave bank donations while utilizing paid leave Oregon. I think that we just see that as sick leave. So yes, I agree, they can use their sick leave bank from the sick leave bank in a PLO situation, it just is sick leave. So I don't know that it needs to be called out separately, but I guess we're open to that conversation. No proposed change to personal time off.
This isn't that why we put it up here. It's a good one.
I have to look at that and get that in context. Okay, moving on. You had proposed a deletion of current language in this next section and the replacement with a designated bereavement leave benefit. And we've agreed to that concept. It's consistent with what we have for classified employees, and we've tried to keep it as consistent as possible with our agreement with that group. We see this as a subject where having language and procedures that are common to both bargaining units makes sense when we're talking about people dealing with death of a family member. And so we've tried to keep that language as close as possible to what we have in that other CBA, which is up to 3 days of paid leave. With that, that's the same list of folks that's in our classified agreement. And so obviously these are days that don't come out of your PTO, they don't come out of your sick leave. This is a new designated paid leave. And then we have 2, 3, and 4, just for some clarifications that people can use paid time off after they've exhausted their bereavement leave. They can use their paid time off, obviously, when we're talking about somebody not on that list. And then just making sure that people know that they have additional benefits under OFLA to additional bereavement leave. So they can take up to 2 weeks under OFLA, and if they want it paid, they then would backfill with sick leave or personal leave. But we want people to know that that's available to them as well. And that's for an even broader group of individuals. So we're trying here to, again, have that sort of combination of the statute and the contract, but are in agreement with a separate new paid leave category, again, consistent with what we have in our classified contract. Temporary military leave, we had made a proposal that I believe you picked up on some wording change there.
Brian, before you go on, can I ask a real quick clarifying question?
Sure.
On page 6, so just bear with me with letters because I think it's gonna be in C.
Okay.
1A, double I, or 2. Nope, I'm sorry, it's in the first one. You list, or it's typed out spouse and domestic partner, but it isn't listed as domestic partner in any of the others where partner is.
Oh, yeah, thank you.
Yeah, just.
Yeah, thanks. We want to be consistent in our word usage, so thank you for that.
Okay. So would it be domestic partner consistently throughout or just partner?
I think it would be domestic partner consistently throughout.
Okay, thank you for that clarification.
Yeah, thanks. I appreciate you bringing that up. Was there anything else on that one before I go on?
No, thank you.
Yep. Jury duty. We saw just, the more you read this contract, the more you see language where you're like, what does that mean anyways? And so, as we read it again, this piece in number 3, it previously said the district will reimburse the employee for loss of pay for time spent. But if we never deduct it from your pay, there's nothing to reimburse, right? I mean, the point is it just, time when you're on jury duty just never gets deducted from your pay. We don't take it and then give it back to you. So it just sounded weird to say shall reimburse the employee for loss of pay because there is no loss of pay. You remain in paid status.
Okay.
So that's what we're trying to make. No deductions from the bargaining unit members' pay, we think is a more accurate way of describing what happens. It's not intended as a change in practice. Court appearances, there are no substantive changes. Temporary leaves for professional activities. And actually, I can probably just say I don't believe in the remainder of it there are any substantive changes. You see a new section K, and that's where our job-related injury or quarantine, previously known as Article 14, shows back up. I love getting rid of articles that are one sentence long, so thank you for that suggestion. That's it. Happy to answer other questions if you've discovered some as we've gone through this, or, you know, maybe after a caucus if you have some.
Yeah, I think we're good right now, thank you.
Okay, sure.
Okay. So how long do we want to look at for caucus?
Let's start with 45 minutes.
You bet.
Okay.
Okay, 45 minutes, thanks.
Thank you.
Janine, do you want us to track them
We'll bring you guys all.
Next time, can we just have personal fans sitting at our worksite?
Oh.
Fans or heaters?
Okay, I don't.
Send that request into Carl, I would like a personal fan and a personal heater, depending on my mood.
By the end of bargaining, Carl's gonna have a giant list.
He's gonna have a long
People will be like, can I have a heater, can I have a, like, we should get to choose heater or fan. And then Carl will provide you with a personal heater or a personal fan.
If you're over 45, then you get both.
Can you request?
Well, I said, we should each get to choose heater or fan, and Carl will provide that for us next time. Each for your,
For individuals.
yeah, individuals.
Your individual plans.
Yeah, there we go. Thank you.
Oh, here's.
What else is he doing?
I'm assuming we're on.
You ready to get started?
Yes, thank
Okay.
you.
Would you like to start first? or
No,
us?
feel free.
Okay.
Yep.
Okay. You ready?
Yeah.
Oh, yeah. Oh, sorry, we're passing 16, sorry.
Okay, if everybody has Article 16 in front of them. The first thing, so this is a counter proposal. The first thing I would call your attention to is we just made some correction in Article C, again, Section C, sorry. Again, as we walked through the contract and found gaps or areas where it didn't align quite right. So we had an omission under military leave regarding to people being deployed or called into active duty. By law, those individuals get unpaid leave of absence. So we're just trying to close gaps and trying to make sure we're complete there. Then I believe that you guys made a proposal at the end of this article that was very similar to what we had gone over in paid leaves. One piece on access to the electronic infrastructure and another regarding subplans. So I think our thoughts on the subplans would be similar to what we talked about under paid leave, that it's nuanced, depends on whether it's an emergency or a planned, a number of different factors. We feel like it's been handled pretty well, so we're a little reluctant to put specific guidelines in the contract on that. On electronic infrastructure, a little bit different when we're talking about unpaid leaves because those typically, or in some cases, can be significantly longer than our paid leave scenarios. So what we've tried to do here is call out those situations where we have people on statutorily protected unpaid leaves. They certainly would continue to retain access to the district electronic infrastructure as opposed to somebody who might have like a full year study leave or, I don't know, I suppose, Susan, what other scenarios would that be, like parental leave or things like that, full year?
We have a provision for a full year unpaid leave, personal leave, that where they don't have to give us a reason. And we, I think, have typically over 100 of our people are out on that kind of a leave. I know the number this year is 190. I'm not sure if all of them are personal, but they're full year unpaid leaves. And so a lot of times that's might be someone working overseas in a contract or just accessing their contractual ability to take a personal leave. So those full year leaves, our understanding is those are not necessarily the folks that are asking for this kind of email access to continue. It's more the unpaid leaves that are partial or related to FEMLA, OFLA, or ADA, or those kind of pieces.
And that's all in Article 16. Questions?
None at this time, thank you.
Yep. we have Article 17 for you as well. So Article 17, you had a variety of editorial changes, and I think we picked up a lot of those. That switch over to bargaining unit member, spelling out Portland State University. I think the substantive change that you proposed was there in A2, A3. And I think for us right now, I mean, here's what we're trying to kind of grapple with. As we look collectively at all of the things being proposed, many of which have a dollar sign associated with them. And how are we prioritizing those? How are we, as we look about it at expanding cost, what are the places we want to emphasize? So we see this as a cost factor, being able to utilize a full 12 credit hours for workshops instead of the 3, definitely a cost factor. I think as we go through the bargain, we're going to need to hear from you, where does that rank in your priority of things? We will not be able to solve all economic asks in this bargain. So where does that rank? Is that something that's high ranking for you? Is it lower compared to some other things? I mean, right now, as we sit here, we don't see that probably as one of the most critical interests that we're trying to achieve when we look at things like insurance, when we obviously our salary. So for us, the current setup includes that allowance to use money for workshops, and then if you're in certain categories, you can expand up to the 12. So it's not one that for us feels like is a place to grow this contract from a financial standpoint. And I don't know that we necessarily costed that out, although we probably could. It's just hard to know, how you would estimate that cost. Anything else you want to add on that?
No, I think that covers it. It's just an added cost and where that plays in the priorities of where we are with everything else we've got proposed.
Mike, could I ask that at some point in the future, obviously not in this moment, that we get an estimated cost for what you guys?
We probably can, yeah. Do you want to sit and chat about assumptions before that?
Not necessarily, just maybe
Okay.
just what you are, in your vision, eyeballing an estimated cost for that particular thing, since you guys
Yeah,
brought that
I can
up.
take a look at that.
Okay.
How, do we know how long ago, I'm sure this was something at some point that was added, if I'm drawing on my own experience in bargaining, it used to just be credit hours towards, tuition, from a university, and then at some point we expanded this. Do we know when that happened here? Because I could probably say, what happened that year? And did it-
No, but I have a way of finding out.
Okay, that might be really helpful in saying, okay, when we had 0 and we went to 3, what did that look like?
I accept the challenge of going through all past contracts.
Thank
notes.
you.
Love it.
Appreciate it.
One other piece we discussed, and it's secondary, I think, to the concerns about just understanding the cost, but the presumption is that college tuition courses often are organized or scheduled around the workday, but conferences and workshops often also take our teachers away from students and have the sub piece as well. Again, that's smaller piece of it, but that is part of what we discussed as well.
Thank you.
I guess a follow-up question that it might be helpful for us to hear from you folks, maybe after you've had a chance to talk. So that increase to 12, was that more because, hey, there's singular conferences that tend to be exceeding the cost of 3 credits? Or is it more along the lines of, we have people who want to take multiple conferences in a year?
We'll get back
Because-
to you on that one.
Yeah, okay, I don't remember from our initial discussion on it, but that would help to know, is it, I wanna go to a conference and 3 credits never pays for it. Or, that's different than I'm trying to go to 3 conferences in a year.
Thanks.
Yeah, thanks.
Do you have any questions for us about?
Not at this time, no thanks, Janine.
And that's all we have for our counters.
Excellent. We have some questions that we would like to ask, starting with Katie.
My question is about Article 15. On page 6. So thank you for the clarification that you meant to make it domestic partner throughout. Our question is, why did you reject our proposal of changing that to just partner?
We didn't talk about that, so I think we were trying to match up with the classified contract, is my recollection. I thought we brought the list in from that contract and then split it up, like, for some reason sibling was included in the same line in the classified contract, maybe as children, grandchildren, et cetera, so we did break that out a little bit, but I think we borrowed from that classified contract and brought it across. So I don't know that we had any conversation about the difference between it being domestic partner as opposed to partner. So certainly willing to have that conversation.
Okay, and as of this time, do you know if you have any objection to?
We didn't talk about having any objections, so I would want to talk to folks, but that wasn't part of our conversation. Like, we want to make sure to limit it only to domestic partners, not partner. That wasn't part of our conversation.
Okay, thank you.
Yep.
I would add, though, that maybe we should look at what the legal language is around partnership. So if, for example, Multnomah County or Washington County is still honoring domestic partnership, that we match the legal language for registered direct domestic partnership, maybe? I don't know. It might be a question that we want to look into.
From a personal standpoint, I've been with my partner for 15 years. We are not married. We are not considered a domestic partner. I deserve to grieve him if he dies tomorrow. Hence why our proposal of partner instead of the legal term of domestic partner.
I think that is covered under the law, though, as domestic partnership of over 3 years at the same address.
A domestic partner is in Oregon, you register as a domestic partner, which is similar to a legal marriage.
Okay, it's an interesting question.
Yeah, we certainly had that conversation. I don't think we were trying to exclude people from taking bereavement in situations like you're describing. So I think, number one, I think primarily we were borrowing that language from the classified. And then number two, I think it's been frequently used, domestic partner has been a frequently used term. So
Yeah.
we
I
didn't
think
have a lot
looking
of
at what other
conversation.
states do is allow, partners tend to be a little more inclusive. And I know, I am not
And I agree
the
with
only.
you, Katie. Thank you.
Yeah.
I hope I didn't.
Oh, no, you're good.
You're feeling
And I would
that
also
way.
say I'm probably not the only, I know I'm not the only person in this room who that falls under.
Yeah, thanks for bringing that to our attention.
Emily is going to ask the rest of our questions.
We have, okay, can you guys hear me?
Yep.
Oh, I can hear you, great. All right, we have a lot of questions about the Article 8 counter, as you might imagine.
Which
So,
number, sorry? 8?
Article 8.
Good.
So we'll wait, if you could look up when you've got 8 out, that'd be great. Okay, we're all good? We're all good, good. Okay, so for beginning with A to B. Specifically, I mean, we're fine with PAI, or we might call it POI, but that's not really substantive, so improvement's good, we're open to improvement. Regarding the previously been on a plan of assistance, we understand where you're coming from conceptually, but we have a little discomfort when we think about how long some employees work with Beaverton.
Mm-hmm.
So is there let's say somebody was on a plan of assistance or awareness or awareness for improvement or whatever, whatever term we have for it. Let's say someone was on that plan 10 years ago. And then 10 years later, they fall by their practice begins to fall.
Mhm.
Would you be willing to reconsider them starting over again because they had so many sustained years of good progress? Or is this a hard and fast position for
No,
you?
I think those are not the situations we're trying to account for by saying they wouldn't first get a plan of awareness. It's more of that cycle where we sometimes have people who successfully complete a plan of assistance, but then once supports are taken away, we might get into the next school year and they fall back in their performance. Those are the situations where we're not looking to put them back on a plan of awareness first. So I don't know what the magic number is, but it's not the 10 years ago somebody was on a plan of assistance. Those aren't really, I would agree with you that in that example, before you went directly to a plan of assistance, you would try other interventions first.
Good.
So, yeah.
Happy to hear it. So along those lines, how unrelated, you suggested in your presentation that the issues could be they had to be closely related.
Mhm.
That is, I hear you. So I just want to test out an example
Uh-huh.
for you. Because, we're not opposed to it, but we kind of need to understand more what you have
Sure.
in mind or how finely you'll separate out the various issues. So for example, let's say somebody was initially terrible at the administrative work and grading in a timely fashion. And then later stumbled a bit in building relationships with students and behavior management.
Mhm.
Obviously, it seems like administrative stuff versus relationships with students and behavior management, that's fairly different, right?
Agreed.
Yes,
Yeah.
okay. But would you say that building relationships with students and behavior management are the same issue?
Yeah, I guess I would see if others wanted to weigh in. I'm probably not as good of an expert to parse out like different parts of the evaluation rubric and say, the first example you gave me, I'm comfortable saying, those are two very unrelated skills or areas of performance where just because you were on a plan of assistance for one doesn't really relate to now you're having a problem in the other. So, I would always defer to my instructional folks on things like that.
And maybe my second, thank you. And
Yeah.
we look, if you guys want to take time to think about that in caucus, that totally makes sense.
Yeah.
I would add a second, maybe a better sort of counterexample. Instead of relationships with students and behavior management, which are fairly enmeshed,
Mhm.
maybe relationships with peers and colleagues and relationships with students.
Mhm.
Would those count as separate enough?
Yeah, got you. Good. Yeah, those
Yeah.
are fair questions and good ones, I think. Some of it depends on what does our rubric look like and how are things separated out or divided out in every district is a little bit different. So I'd be interested in seeing that. But we're talking about, in broad terms, different areas of deficiency, in my mind. If it's the same area of deficiency, then we wouldn't expect that you would go back on a plan of awareness first before going on to a plan of assistance again. If we're talking about different areas of deficiency, then I may be different.
Okay.
I'd invite anybody who operates the evaluation system to chime in if.
One of the thoughts I have is just with our 5D, if someone is on a plan around a particular, we usually will have to identify the exact line within there that's most closely associated with that issue. So if it's in that same domain, I can see that we don't go back.
That's what I would think.
But if it's in another domain, it's a different issue, then I too, at least at the building level, I would be kind of starting fresh with the assistance for that.
I agree with
teacher for
that.
area.
Okay, that's useful information.
This
Thank you.
conversation mirrors what our practice has been in the last 10 years.
Okay.
We literally do look at it that way and evaluate it. And if it is in the same area, then we would consider it to be continuation of the support.
Yeah.
Okay, thank you.
Yeah.
All right, going on. Let's look at 8B. Evaluation of students. So we have a couple questions here. How much effort were you imagining an administrator might undertake in attempting to make contact with an employee? So, for example, we understand this, like, what happens if, clearly, you probably wouldn't go to the effort to seek someone out if they've been separated from employment with the district.
Yeah.
No argument, that's fair enough.
Yeah.
But what if you're on leave? Or, yeah, like, what if you're on leave?
I mean, I'm guessing you'd use their district email, send them an email, I don't know,
Or personal.
or if we have.
Or personal email or phone call. I would make a phone call. Several of them, with messages.
We appreciate you. That everyone were that thorough. So, that being said, to that point, do we believe that there's a consistent practice across the district amongst administrators? Like, that's part of our concern and why we want to prescribe a standard practice, is that not everyone is as excellent an administrator as we have before us today. So, another question, what time limit, one question we had is, especially about the secondary level in high school, there can sometimes be students coming to administrators seeking a grade change years later. Is that, and that's a practice that doesn't necessarily make instructors feel super excellent. So is there any openness to maybe limiting that practice?
I don't know enough about when and why that would happen.
Sometimes it's about trying to get, I've heard that it's either in anticipation of applying for college or in anticipation of trying to graduate.
I don't know, Matt,
Yeah.
might be.
Well, in my 6 years at Aloha, I have never had that scenario of years later. It's always been within weeks at most, usually by midsummer is the most common if thinking about an administrator or a teacher who might not be available. We're usually talking that summer. So, again, I haven't had that scenario. I'm trying to channel my peers. I can't imagine us necessarily being open to changing the
Because
grade years later.
what documentation would they provide to say, you should
Exactly.
change my transcript?
Exactly.
Well, so if we might, we
Please.
appreciate that, thank you. But we also, Adam, would you like to share your experience?
Yeah, there's a member at my building who was approached by a vice principal earlier this year about a student they had 3 semesters back, whose parents came to the vice principal multiple times about a grade that they were disputing. The vice principal asked that teacher to try to reassess the student's grade 3 semesters later. Teacher obviously is like, the grade is what it is, I don't have the time and effort to go back and do that. So that was an actual case this year, in which it did go back much further than just a few weeks.
Interesting.
So something to, that is
Yeah.
where we're coming from.
Excuse me, do you
yes.
have more examples, or is that the only example that you have? I'm not saying that's not merited, I'm warranted.
I actually had a student come back.
And Mike.
Oh, sorry. I had a student come back about 4 years later to change a grade, if you can believe that. So, it happened to me personally, and had some administration that was wanting to change the grade. So it was a long time.
Thank you.
Can I go back and change some of my high school grades? My calculus grade was terrible in high school.
Yeah, I don't know if there's an actual statute of limitations, but when I was working with high school kids, getting credit recovery, we had one kiddo that had a grade that wasn't acceptable for graduation, and they just went back and took the course over again. So, I don't know.
Yeah, that's-
I've never experienced that
Yeah.
either.
Okay, interesting.
That's why we want everyone in the room to have all the information.
I think there are unique situations, because I do understand what the gentleman said about added work. So when that happened to me in my previous school district, and it was a middle school, so it really didn't affect graduation itself, but there were families that were like, no, my child deserves an A. I did inform the teacher, like, this is a concern that was brought to my attention. Can we work through this? And the teacher was compensated for their time to kind of, you know what, I get what they're saying. Let me just go back, take in an hour, 2 hours, whatever it took. And then the teacher was compensated for it. So I think it's just, the situations can vary very differently from staff to staff. And as long as we're upholding other parts of the contracts that can be applicable to that situation, would be pertinent, right? And having those conversations and that direct communication with the educator about the nuances of that situation is super important as well. So it's just hard to like pinpoint exactly every scenario that can come out of it. But what's important is to uphold other components of the CBA to make sure to support the educator with that.
Thanks.
That makes sense.
I heard you, yes, thank you. Additionally, I noticed that we had a request or not request, our proposal, our previous proposal was that the notification be in writing. And that it be, we also required consultation before the change. And it's not hard to understand why, given the stories we just shared, right? So is there a reason why you felt it was necessary or we would like to understand better, so we can counter you, why was written taken out and why consultation prior was taken out?
So the consultation prior, I read as being part of current language, and that's where we wanted to have it read unless the employee is unavailable. So I didn't see any additional language about consultation in your new proposed language. The written component of it, I think, was to reflect what Lori was saying, that sometimes that might be a phone call. So I think we were just trying to account for the fact that communication could occur in different ways.
And we acknowledge that, and we love a both and approach, like we of course would love a phone call and it in writing. But I think that both parties are better served by having a definite record of a conversation about something as sensitive as a grade change.
Sure, understand that.
Yeah. Okay. So, moving on to D2. Just a genuine question here. Is there a official process by which district guidelines are developed? And what sort of input do educators have into that process, bargaining unit members have in that process?
Sure. Official process, well, I guess it would depend on, that could vary guideline to guideline. So if I even go back to some of the ones that I sort of rattled off, so like the SBLS expectations and considerations, that was actually initially developed TNL with large teacher input. I was in TNL back in those years when it first got developed, and so we had, probably 50 teachers involved in that.
What types of things are in those guidelines?
Yeah, you can actually still pull it up. There's an expectation side and a consideration side. So like on an expectation side, it might say that you assess each learning target, academic learning target, and then you assess behavior targets separately. It's a district expectation. That's the way we do business. Where on the consideration side, it might address that the teacher chooses what they call the word just slipped my mind. In Synergy, they can choose the aggregation method that they want the gradebook to use to develop a recommended summary judgment. So it speaks to those sort of things. And so that was a large committee that sort of worked on what should be fairly consistent and where should teachers have various. So, but that scenario doesn't necessarily so Synergy gradebook setup is a different set of guidelines, and I don't know that I was necessarily involved in that one, but I probably had IT involved with it, TNL involved with it, so the TOSAs there usually play a big role in that, but it's much more a technical set of guidelines. So I don't know that I could, or that there is a single answer to say here is how all district guidelines get developed. It would vary depending on what the content is.
Okay, that's informative, certainly. So to sort of draw us back to the bottom of 2, this is one of those fun articles that's split between pages. What I heard so I'm just going to read the language because it's pretty clear. The association and the district acknowledge the fundamental need to protect teachers from any censorship or restraint that might interfere with their obligation to perform their prescribed teaching function. And I guess my concern or my question here is, are the guidelines that are listed in your add-ins, they seem to be more about expectations for professionalism and less about content. To what extent do these additions actually accomplish what the beginning of the paragraph set out as this provision's purpose?
I think it more goes to that second sentence where we then say educators shall be free to use their professional judgment and assessment of students to make decisions regarding methods, materials, sequence, and timing of lessons. So as we start getting into those concepts, yes, that's true. People do have autonomy in developing and deciding on materials and sequence and methods and things like that, but they are within, so I think it's the guidelines tend to interact more with those pieces, I think, than that first sentence.
I believe my colleague Sarah has something to say.
Microphones. I would just say that, like, I think, and I was just flipping to the original language here to just reference it. It seems that, in my understanding of the original language, it's pretty wide, right? There's that wish to defend against censorship, basically, as a theme. And then it feels counterintuitive to then have a list of a ton of things to make sure that it's really specific. So there was some curiosity around mismatched intent that we wanted to flag for consideration.
Yeah, I think for me, I've looked at that, and sometimes it appears in two different contract sections or at least paragraphs, protecting against censorship and the ability to discuss controversial subjects when necessary and things like that, to me is one concept. The obligation to use district adopted curriculum or follow state guidelines on what we need to present in schools, to me that is a slightly different topic. So I think this paragraph's trying to accomplish multiple different things, and I think our proposal is more related to that second concept, I would say.
So, well, we can counter that. All right, so going on, in E3, we have a couple of concerns with we have a number of concerns. So, there we go, okay. First, I have a sort of conceptual test. I wanted to test my comprehension of what is intended by intentional act of destruction. Is a dysregulated student who harms a teacher engaging in an intentional act of destruction? Or a dysregulated student who is communicating something through their behavior, the communication is destructive, and they go through ripping things down the walls of an elementary school classroom? Is that an intentional destruction of property?
Yeah, I think you're asking some of the questions that we ask ourselves even as a team. Like where we can imagine some of the behaviors that fall very clearly on the side of assault or intentional destruction. And then we can imagine some behaviors that are so purely, accidental with no ill intent that they obviously fall on the other side of that ledger, right? So it's this middle category that we do struggle with, and we had that conversation as well. So, I think it's really gonna depend on the facts of the situation as to how that is assessed. Which I know is difficult, but we're trying to accommodate or account for very complex situations, I think, in this paragraph already. How do we define what an assault on somebody is?
Laura, would you like to speak to that? Yes, please.
Yeah. So I work in a specialized program in the district at the elementary level. And so in thinking about that phrase, that comes across a lot like we assume the intent of a student who is dysregulated, that they are being intentional in their destruction. And we're just curious why we would want to define students' struggles or maladaptive behaviors as intentional, and if that is what you want,
Mm-hmm.
how you guys want to frame students who are struggling with behaviors.
Yeah, again, we had some of those same conversations and, other folks can chime in too, but we did talk about, to what degree does age play into that question, or cognitive ability, or lots of different things play into whether we consider it to be intentional. What we were struggling for and reaching for is some way to exempt out those things that are purely accidental behaviors that may happen in a school environment, that we don't necessarily believe the district is responsible for every single occurrence of those things. So if there's a better way to say it than intentional, let's see how we have phrased it, intentional, deliberate, intentional act of destruction. I think we're open to suggestions there, but I think we were a little bit wary of the broadness in which you had proposed it, and we were trying to put some guardrails around it.
We hear you, but I think part of our broadness was reflecting the reality of a range of student behaviors
Mhm.
that can impact and harm teachers and
Sure.
other students. So, but we will counter. Thank you. Your message received.
Emily?
Yes.
I'm just gonna pause for just a second. We were supposed to end at 4, so I just wanted to do out of starting and ending on time to everybody to see if people can still extend their time.
And with respect, starting and ending on time, we were supposed to start at 12 and we did not start until 12:20. So my team would be open until going at least until 4:20 to reflect that end-to-end start on time.
I know people have obligations, that's why I'm just asking, yeah. So is everybody available to stay a few more minutes?
Yeah, you thinking that's about your general, think you got 10 or 15 more minutes or so of questions?
Yeah, I think we
Okay,
can move to
yeah,
that.
sounds good.
Thank you.
Yes. All right. So, same section. Why is assault back in? Is that also an attempt to limit the scope of in E3? Why is or assault, wait, where is assault? 4, yes, E4.
Could you repeat that?
Yeah, I'm not
You know-
hearing, I'm sorry, I'm not hearing your question
That's
well.
So we removed the language in our counter to describe it in a different way, to not use the word assault for a number of reasons. Many of them related to the concerns and queries that Laura so beautifully framed. So why, we'd like to understand what you were trying to accomplish by reintroducing that assault,
Section titles.
the terminology of assault.
In the section titles, Brian.
What's that?
It's in the titles.
It's in the titles, yeah.
Yeah, I think that we were looking to incorporate both the current standard, which that's what the current standard is, and then expand it not as broadly as you've expanded it. So the way you had written it, as I think you had used the action taken that impact a bargaining unit member's person or workspace, we interpreted that to be a very broad scenario in which the district would have responsibility to compensate people or reimburse people. So we were looking to recognize that not all situations might involve an actual assault on somebody, but we were not looking to make it as broad as the way you introduced it. So our method of doing that was to keep the current standard and then add those other situations which it could apply to.
Okay, understood. So along those lines though, part of what would seem really helpful in trying to clarify and make distinguishing, we acknowledge, both parties acknowledge we're sort of in the range, there's going to be some management discretion involved. There's going to be some judgment calls involved in this stuff, unavoidably.
I agree.
So we're a little more, it's more surprising that the district did not pick up on our request for a standardized reporting form. It seems like it would be in both parties' interests to have a standardized mechanism for collecting this information. So can you tell us more about why that, we hear you, it doesn't exist.
It doesn't exist, yeah.
So why couldn't it exist?
Yeah, and I'm probably not the expert on that. I mean, we're a pretty large organization, so the creation of any centralized system does involve some level of coordination and work. And so probably not the person to say exactly what that would look like or how difficult that would be, knowing that we don't have that system right now.
Okay.
So, I mean, we can talk about it and get back to you with what we see the barriers to creating that to be.
We would welcome that information because
Sure.
I think it's an essential we need to do this both, I mean, as we said and have said repeatedly, behavior is communication. We can't support our students if we don't understand both on a local level and a systemic level what's being communicated to us.
Emily, I do
yes,
have a
please.
comment about that. Having been the previous, leadership team coordinator for PBIS systems in the district, and I realize that that has gone out of vogue and we're not always using that now. But back then, we did have a universal set of forms. And we also took that information from the standardized referral process that was available at the time in Synergy, and I believe may still be available for middle and high school use. Behavior referrals, is that right? That they're still available?
Sure, I mean, Synergy is still used across all.
So, and at the elementary level, we do put instances where children have consequences that fall within the Synergy categories. We do log those in Synergy as a practice, at least at our building. What we found when we were using Swiss and those kinds of data collection systems was that although the form was standardized, the evaluation of the behavior or the incident is so subjective and so contextual that it's really, really difficult because you end up sometimes comparing apples and oranges in the same form. And so that's one of the I think considerations that we need to think about when we think about a district maintained standardized form, that it's not really standardized unless we're doing all of the professional development, all of the deep understanding about behavior and situations, which will take a lot of time and money. So it will be, if we were to do that, it would take a pretty significant amount of time to get that going, just, in my experience. Okay. So thank you for listening.
Of course.
Emily?
Yes.
I have a follow-up question. I just am curious to hear more information about how you're seeing the comparison between the word assault and harmful acts. It's interesting, and I hadn't thought about that too much. So I just love to hear a little bit more, because I think the word you used is harmful acts.
Sure. I would love to answer that, but I think, can we get through our questions and we can answer you next time? Okay, because that is a great question, and I'm happy to answer it, just not right now. Okay, so moving on, in I. So we were, I believe Curtis said that, you believe that OSHA was incorporated by reference, if I'm summarizing you basically. Would you be opposed to us listing that out? I think it would be helpful in giving our members the resources they need to actually make sure the contract's being followed.
You mean instead of state and federal laws?
Yeah, I mean.
Referencing OSHA?
Yeah.
No, I don't think I have an objection to that. I have quite a few contracts that say we're gonna follow OSHA.
Okay, good to know. Okay, and
Sorry,
then.
Curtis, did you have a different answer than that?
Well said, Brian.
Okay. So, regarding job descriptions in K. How often are job descriptions updated?
– Last one that, since I've been here the 4 years, that was done was last year for the social workers. But looking at the dates are on there when they're updated,
Yeah,
so,
we noticed
yeah.
them, yeah.
And
I can't
Janine,
recall.
that was not an update, that was
Oh, that was a new one.
creation.
Yeah, that was a new one, you're correct.
The updates are fairly infrequent for licensed job descriptions.
Thank you.
Could you say that again, Susan? I might have missed that. Could you say that again, fairly often?
Infrequent.
Infrequent. Well, and so toward that end, when and how are people within that job description notified that a description change has been made? Either is the association traditionally notified when it happens, or do people say, for example, student management or student success coach? Like, let's say that one's altered, would the student success coaches be notified?
Well, I just want to say, like, the date you said was 2015. It's common to see many, many years. So in the 4 years I've been in this position, I'm not
sure we have changed job descriptions. You will correct me if I'm speaking out of turn.
Well, I do remember the creation of the student success coach position, and it did change, and I do believe that it was sent out to student success coaches and also shared with building administrators.
It's on the website too, but again, that was creation.
Right.
So
But they are-
changing them is
yeah,
really rare.
We don't ever, yeah.
Okay.
But there was a change and it was communicated at their meetings.
Okay. I think a concern was actually specifically around student success coaches, is that perhaps the use of the like what the description says and how they're being employed, there's a bit of daylight between them. So we were wondering how often they were updated because of that discrepancy.
I can talk about that. And actually, we've been having that discussion in TNL, especially around school support specialists, who also are in a little bit of a limbo with their job description. But when I meet with them, I tell them that because they do give me the same information that they've told you, what we're doing doesn't really match. So I work with them, I talk to them, and then I work with TNL, but nothing has been done yet, and then I would work with HR, so it would come together that way. I can speak to that. I don't know about the history and all of that, but they have voiced that, and I am working to address that.
Thank you. Okay, and then, so I think that's all so for evaluation, last bit of questions, we're almost done. You mentioned that the evaluation instrument, or Susan, I believe you alluded to the evaluation instrument being, or the handbook being bargained. Do you have a sense of when that might have taken place?
A couple of bargains ago, probably. Yeah, and what it was is, it was an effort. I know the people that were at the table. If I say the people, then maybe we can understand when it happened.
That's your names, yeah.
It was, I believe it was Karen Lawley, anyway, I don't need to say their names. Couple bargains ago.
Honestly.
Couple bargains ago, I was gonna say, and it is on the website, it's called Processes and Timelines, and the idea was to share an understanding of what the expectations are for evaluation, but also to demystify plans of support. I think that was a big part of it.
Yeah.
Was people didn't feel like they had any resource to go to that was neutral, dispassionate, to understand what does it mean. They see the contract that talks about plan of assistance and plan of awareness, but just to understand how that all fits into the larger piece. So there were 3 members on each side, much like some other task force that we make sometimes, and we wrote that together.
Okay. Given the living nature of the document, which I think was your phrase, given the living nature of the document, is BEA consulted, or are we consulted prior to changes in the evaluation system being made?
I know we did use the term living document, but we have not changed that document since we published it, and nor have we changed the process that it describes.
Good to know, thank you. Those are all my questions, thank you.
Yeah, thank you.
I recognize that it is 2:23, so I'm gonna put 4:23, but I'm gonna put forward a question. We have an article that we are in complete agreement with. If you would like us to save that TA for next time, we're happy to, or if you would like us to.
No. I want to sign that TA right now.
Absolutely not.
Are you
I
kidding
thought
me?
I would just put it forward to
Come
the table.
You know I like the sounds of that.
So we're gonna send it to Michelle right now.
Sorry.
I
tried to. I didn't even see it.
I was saving that for a happy, warm moment, but we're sending it to Michelle right now, so we just need to get it printed and then we'll be able to. It is Article 6.
Awesome, fantastic, yeah, thank you. I do want to stay and sign that. We meet again fairly soon.
Yes. Next Wednesday.
I don't know that we completely know right now what we're gonna bring, so we may need to be in touch with you on that.
Yeah, Suzanne, you and I can chat. So it's 12 to 4 next Wednesday at your BEA office.
Correct, yep.
The owls will be ready. The owls will be ready.
Okay, so Michelle, you sent that to Michelle, she's printing it out.
It's being sent imminently.
I just
So-
can't see Michelle to know if she hears that it's coming her way, yeah.
Should I send it to somebody else?
Suzanne?
Yes.
Can I just wrote a note on March 15th when we received Article 4, and I just wrote a note for myself that said need accompanying appendix. Was there another document that we were still waiting on from you for Article 4? You can look for it later or find out if maybe my note's wrong, but I just saw that note and I thought, I think there was another piece to that.
I'll flag it and see, get back to you.
Thank you.
Yep.
I missed that. Do you get it? Do you have it written down?
Yeah, Article 4 and missing appendix.
Okay, thank you.
I think it just had that one little piece on the top that we added to the appendix about how we encourage problem solving at the lowest levels. It wasn't a substantive change, but there was a little change.
That's theirs.
Just out of curiosity, who signs the documents?
Janine and Suzanne.
Sorry, I missed that.
That's
What happened?
who signs the team.
But Lindsay was supposed to get special pins.
Oh, seriously?
With a feather.
Oh,
They were gonna
remember?
have each article on the pin.
Oh. Each article on the list.
Yeah.
One pen, like inscribed.
And then you could, and then it was a ceremonial
Right,
and
we did
you
talk
could
about
gift it
that.
to somebody.
Passing the pen. I signed it with this.
Like in the
I want the pen for.
I left her TA.
Erica, and correct me if I'm wrong, BSD was gonna pay for those pens, right?
She didn't even hear you.
She's ignoring.
I think It goes on Mike's list.
Oh, Mike, is that correct?
I'll pass the collection plate around.
Our office is unavailable.
I have an appointment, but thank you for your time today.
Thank you.
Thanks, Lori.
Yeah.
See you soon.
3 sections. What is that? The older
I wish we had kept the date for the last one, the first time that we TA'd something. Like, when did that happen? Are we ahead of the game in this one? Like, how are we feeling?
I think so.
wise?
Well,
I think we're well
I think
ahead
we
of
are.
the game, yeah.
But like months.
Yeah, little
Like
calendar of
quarters.
successes.
Oh, okay.
I think we're ahead of it. Sit in the car for an hour and a half.
First. Yeah, Erica, your reaction was right. It's exactly what we were hoping for. Excuse me.
Just like all the stars aligned. Hillsborough on Tuesday, Hillsborough on Wednesday, Beaverton on Thursday. Well, I told Constance, the next time you guys schedule HCU and HCA recommendations. Yeah, and then we figured that would actually save my money because it would save an hour driving home and an hour driving back. You know, and so I could get a hotel for less.
No.
Are you really?
I'm gonna be around.
You want that, you're trying to earn some income. Yeah.
You don't care. You what?
So that's why this morning I got back from car, I was like,
Oh.
I'm driving 205 to 84 today.
Tried that last time.
I'm going, I've done that 2 days in a row, I'm gonna go 205.
Take my other ugly face.
I'm going to 205 to I-5 to 217, which was infinitely worse. Oh God, it was so brutal. It was so
God, I did promise you my backup.
from the get-go, completely stopped. Oh, yeah. You're there. Matt, you live near Lois? No? Oh, that's it. something of a drive. You get
30 minutes if I'm early.
you get the joy of Highway 26.
I think we're still.
No, you have a crowd. No, it's a needy group.
I keep like equalizing.
Oh.
Social conscious,
Yeah.
social
At the same time?
Suzanne, bend down and act like we're about to end it. Social media, come on.
Yeah, now go.
Good background too. It's great. Okay, it's going on Instagram right now, on the gram.
I think I said that.
Everybody.
She's good.
we have another one?
Sorry.
Today,
no,
I think this would be like, it's Article 6, what do we teach?
That is everything. Thank you.
Thank you. Thanks, guys.
Thank you.
See you guys next week.